Yes.
Dr. Rejman, before we leave the topic of the HIV haemophilia litigation,
Yes.
wanted to ask you about a memo, a minute you wrote in February of 1991. Could we have DHSC 0004766_068, please, Paul? So we can see it's a minute from you to Mr. Powell in the DH's solicitor's office. You refer to a brief conversation with Dr. Peter Kernoff at the Royal Free Hospital, who had received a couple of writs in relation to hepatitis infection. And you observe in paragraph 2 that those are individuals who are HIV negative and so wouldn't be covered by any general settlement of the HIV litigation. And then you say this at paragraph 3, I believe that any that are HIV positive would have to agree not to raise hepatitis in any future litigation. But this obviously does not exclude those not in the scheme. And as I know you'll appreciate from the evidence that you've provided in writing to the inquiry, it's what's set out in paragraph 3 of that minute that I particularly wanted to ask you about. That's an expression of your view or belief that as part of the settlement, those involved in the settlement who are HIV positive would have to agree not to sue for being infected with hepatitis. Is that the right way to understand paragraph 3?
That is correct, yes.
And we know that there was in the final settlement agreement and then in the documentation that the McFarlane Trust required to see, effectively an undertaking waiver, however it's been differently described in various stages, which effectively prevented those who were HIV positive from also bringing claims in relation to hepatitis. So that was the end result.
That's correct.
Now, you've responded to a suggestion that document suggests that you were the architect of that proposal in your second witness statement,
yes.
and I just want to look at that, if I may, with
yes.
you. WITN 44866025, please, Paul. And if we could go to page 11, no, actually that's the wrong page, sorry. Can we go to page 4? We pick it up in paragraph 15. There's reference to that minute of the 22nd of February that we've just looked at. And then there's a reference to the oral evidence of Mr. Evans, Jason Evans, and the suggestion that you were the architect of what would later come to be known as the waiver. And this is what you say, and this is what I want to explore with you, Dr. Rejman. You say you disagree with the allegation. My minute was not the genesis of the general undertaking. I was conveying a concept to DH officials that had already materialised from discussions between the legal representatives of the plaintiffs and the defendants in the HIV litigation. Sorry, I've just noticed that the version we have on screen has the paragraph redacted at the bottom of the page, and we ideally need the unredacted paragraph. I can read it out in any event, yes. Don't worry. You then go on to say that the idea of a general undertaking by the plaintiffs to discontinue claims against the defendants was raised and discussed long before my minute of the 22nd of February 1991. You then refer in the following subparagraphs of your statement to various documents that were made available to you for the purposes of the statement. Yes. You say you don't know, you wouldn't at the time have had access to communications between the Department of Health solicitors or the TSOL, yes. And what was being said, for example, on a council-to-council basis. You wouldn't have known that.
I wouldn't have known the precise detail, but looking, obviously I cannot recall the precise circumstances, but looking at the papers that have been provided to me and reading what I said in that minute to Mr. Powell saying, I believe, which suggests not, I think it would be a good idea if we did this. it is the understanding that, my understanding that that has been decided. And all that I'm doing is I'm reminding Mr. Powell, I can't remember who else was actually copy recipients of that. I think it must be Mr. Canavan and somebody else.
Mr. Canavan, Mr. Dobson and Dr. Pickles.
That's right. So in a sense, I suspect that even though the minute is addressed to Mr. Powell, and you'll find this with a lot of the minutes, the person you're addressing may well know what you're actually saying in the minute, but it's the copy recipients that are the ones that are not aware, and in a sense you write to the recipient so that if the recipient feels that what you have said is incorrect, he can or she can then write back and say, sorry, Dr. Rejman, I think really this is what we have agreed, or this is what has been agreed. It's not what we have agreed, it's what has been agreed, or what is under discussion.
Now, but just before we look at the remaining sub-paragraphs
Yes.
that are on this page of your statement and the next, as I understand it from your statement, there are two general points that you make then by reference to
Yes.
a more detailed exposition in your statement. The first was that there had been discussions prior to the 22nd of February about settlement of all claims and words
Yes.
to that effect. We'll look at those
Yes.
examples in a moment, but that was the first point you make. The second point you make was that hepatitis was something which was an issue being explored in the litigation.
Yes, very much so.
Can I just deal with that second
Yes.
point, first of all, to see whether we can agree on the way in which hepatitis featured in the HIV haemophilia litigation? There were references in the HIV haemophilia litigation to what the department should have known about hepatitis, is that right, and the risks of transmission of hepatitis?
Yes.
Because they formed part of the springboard for the argument, for example, that the government should have done something to establish self-sufficiency at an earlier stage.
Yes.
So hepatitis was being relied on in that kind of way, is that right?
Yes, but also yes, but it was more of a general concept, and in essence, the litigation mentioned hepatitis. It was through. I mean, say, I don't know. I didn't count the pages, but if you counted through the pages, the number of times hepatitis appeared was, it was all the way through it. It was, in a sense, you could have taken out the HIV haemophilia litigation bit completely and just made it about hepatitis.
Except what would have been crucially missing if you'd done that was a claim by plaintiffs for damages for having been infected with hepatitis. That
Yes.
was never part of the HIV haemophilia litigation,
No,
was it?
because basically the litigation was called HIV haemophilia litigation, and I suspect, judging by that stage, this was 1988 to 1991, people were aware that hepatitis C did have significant effects. But I suspect, particularly if one looks at the public perception, and I think what one cannot remove from the whole of the HIV haemophilia litigation is the fact that there were MPs that were pushing about this. Newspapers were forever commenting about it, some more, some less. So, and there was a public perception from everybody, look, these people have got this terrible disease which is going to kill a lot of them in a very short space of time, and this is why this litigation is so important. If one had done the litigation purely on hepatitis C, or non-A, non-B, well, it was hepatitis C by then, sorry, on hepatitis C, then would they have had the public interest? Probably no. Would there have been the pressure, as much pressure from individuals? Probably no. And I suspect that that is the reason why HIV had to be the main point of the litigation. And hepatitis C, although it figured so prominently throughout the litigation, and obviously, with the best will in the world, the Sunday Times is not going to give you a copy of the MSc. And a lot of the people were obviously chasing headlines and what is the thing that the public are interested in. So I think, to be honest, there was so much hepatitis C in the litigation, it couldn't be sort of removed from it.
Well, let's leave aside, if we may, what might be regarded as a degree of speculation on your part as to the motivations of others involved in bringing the litigation.
I'm not suggesting that was motivation. I'm just suggesting that in reality, you know, anybody on any of the solicitors acting for the haemophiliacs would have just said, well, look, this is a no-brainer. This is obviously what we need to do.
But I think we can agree that as a matter of fact, these were claims for having been infected with HIV and HIV alone. Those were the actual claims in the litigation.
Those were the claims at the time.
Yes.
Now, I think one of the problems was, as I mentioned earlier, there was an original MSc, an amended MSc, a re-amended MSc, and a further re-amended MSc. So one doesn't know what would have happened between the last re-amended MSc and the time it went to court, whether they would have actually thought, well, we may have a case for hepatitis, let's throw that into the ring, so to speak. But in a sense, it was in the ring.
Now, if we then go back to the statement on the screen and go back to the first of the general points which you make, which was you say there had been discussions or documents earlier than your minute of the 22nd of February 1991, which talked about settling all claims or relinquishing claims and so on. And you've given here the examples that have been, you've identified from the documentation made available to you from your legal advisors. And we can see the first is a letter which talks about compromise being based on full and final settlement of all claims by the plaintiffs against the defendants. Now,
sorry, could I just butt in there? I think throughout this there is going to be this reference about the special treatment of people with clinical management concerns, because that goes through all out of it. Because I think that is an important aspect of this, that there were two parts to this. There was the main body of what the solicitors on behalf of the haemophiliacs were claiming, but also there was the subgroup of the clinical management which had to be separated out later on.
Okay. So is this right, that there were claims common to all plaintiffs?
Yes.
Based upon the broader, bigger allegations in the main statement of claim, which raise a whole range of issues, including self-sufficiency and other issues. And then a subset of the plaintiffs had additional individual medical negligence claims.
That is correct.
Saying, well, I should never have been, this is just a hypothetical example, I should never have been given in 1985 as a child a factor VIII concentrate or a commercial concentrate.
And I think there was one case where an individual was given unheat-treated factor VIII after August 1985, after the, well, I'm not sure it was an edict, but basically the instruction from the Department of Health that nobody else was supposed to be given unheat-treated factor VIII.
And I think we see those individual claims sometimes referred to in the documents as the medical negligence claims. Is that right?
Yes, thank you.
So if we just look at it, there's a letter from Pannoni Napier, the solicitors for the plaintiffs, referred to in paragraph A of your statement, which makes a reference to if there is going to be a compromise based on full and final settlement of all claims by the plaintiffs against the defendant. And then the reference to clinical management. So we'll leave that, if I may, to one side, because I think that's a separate issue. Now, that doesn't refer to hepatitis, of course, in terms, does it?
No, but it refers to everything. You see, this is I mean, as I say, I didn't see it at the time, but reading it now, and it would appear to be a blanket covering everything.
Covering everything what? Every claim?
Well, basically, of all claims now, the argument obviously is, does that mean all claims in the future of everything? But one reading of that is that there will not be any claims in the future about any of this from the plaintiffs.
How does one define of this?
Sorry?
Well, any of this, you say. How do you define any of this?
Well, any of the matters referred, well, if we go further on, in fact, there was in one of the drafts of the trust deed, I think I made a comment that in fact it was too wide because it would cover everything remotely to do with the use of factor 8, etc. Now, reading this, it suggests that basically there would not be any claims against DH or others in respect of the treatment of haemophiliacs.
Right. It may be that another interpretation is all claims, that is, all the claims which have been made in this litigation by the plaintiffs against the defendants. Might it not?
It might be, but I think the thing is, on that basis, you would need to read through the whole of the MSc and see whether anywhere there is criticism. Well, there was criticism of hepatitis non-A, non-B.
I think there may be a difference between your reading. I appreciate you're not a lawyer, and those of us who have been lawyers for years.
Yes, of course.
Where a claim is what you're claiming about, which is generally, in the injury context, is generally the injury or disease you have suffered, full stop. The reason for the claim is that you say that there has been a breach of a duty owed to you by the person you're claiming the money or the compensation or whatever it may be from. So the claim is what you have actually suffered. The reason for the claim or the basis for the claim is then set out in, generally speaking, in the start of a document. And in this context, it's a claim for everything that went on leading to the fact that individuals claiming that it was in breach of duty that they suffered HIV infection. I don't think the claim was for hepatitis infection.
Yes, but you could look, I mean, say, as a non-lawyer,
I appreciate you're a non-lawyer, and you're going to tell me how you saw it.
Yes, no. As a non-lawyer, and reading this, claims not only, to my understanding, the claims are the whole body of the statement of claim. Now, if in the statement of claim you say that had there been self-sufficiency, that there was not self-sufficiency, and the department is at fault because of that, and if that is part of the claim, which it was, then, now, obviously that didn't really relate to hepatitis C, but, you know, one could actually interpret that any part of the MSc, in whether it be on process of how things were done and everything else like that, any bit of that where there is an allegation about failures by the Department of Health, then that also is covered by the claim. So I suspect that people reading through the claim carefully might well say, well, look, this actually refers not only to HIV, but also it does refer to hepatitis C. So therefore that part they cannot sue on. And then it all gets into a real mess.
So your reading of it was that the expression all claims really meant all complaints.
Yes. Now, so I hasten to add, this is my reading today of a document I didn't see at the time.
Well, yes, it's the time you're being asked about, of course. But anyway, Ms. Richards.
Yes. So that, in any event, the Chair has explored with you the issue that I would have explored with you in relation to that sub-paragraph. In the next paragraph, it's redacted on the screen. I'm just going to read it out, just so that there's no mystery. The reason it's redacted is because you refer in that sub-paragraph to advice given by the Plaintiffs' Counsel in the litigation, and there was an issue as to whether that was still legally privileged or had lost confidentiality and can be referred to. The Chair has resolved that issue by saying it can be referred to, but the document on the screen is out of date in that regard. We don't need to look at the document itself. I can read out what's said in this short paragraph, yes. And I think in case you need to look at it, you've got a hard copy of your statement. Yes. So You say at paragraph 9 of the advice from the Plaintiffs' Counsel on the settlement of the HIV litigation dated the 12th of December 1990, the Plaintiffs' Counsel provides an outline of the proposed settlement negotiated with the defendants for the plaintiff's consideration, stating that, and then this is the relevant phrase, in return for a cessation to the litigation against all the defendants, the DH would make payment into the Macfarlane Trust. So that's the phrase you point to, in return for a cessation to the litigation against all the defendants.
Yes.
Now, would you accept, well, first of all, you obviously didn't see that document at the time, and you've seen it for the purposes of providing your statement for the first time, is that right?
Yes.
Secondly, would you accept a cessation to the litigation is not, perhaps on its most natural reading, the same as saying you won't bring any future claims for hepatitis or for a different infection?
Well, as I explained to the chairman, it is a case of interpretation, and I do not know. Say that would be up to the lawyers to discuss at the relevant time. But reading it as a non-lawyer, my understanding would be that it meant everything that is included in the litigation will not be litigated against in the future, and one would have to go through it with a fine-tooth comb to see exactly which parts of the MSC would actually be part of a litigation for hepatitis C.
And then if we go over the page, I think it's essentially the same point that arises in relation to the further 3 documents you referred to. So you refer to an article in the BMJ, this is subparagraph C at the top of the page, which refers to uses the term settle their legal claims. Paragraph D, you refer to a minute from Mr. Canavan, January 1991, which refers to signing away litigation rights. And then E, you refer to an early draft of the proposed terms of settlement, or proposed detailed terms of settlement, which referred to discontinuing actions and then undertaking not to bring fresh proceedings. Is it right to understand that you didn't see C at the time, the article in the BMJ?
Sorry, C, yes, that was my copy.
Oh, okay. But at the time, do you think, was that something you'd have paid any particular attention to?
Yes, because if you look at that article, if you look at it, it's got my writing on it, please copy to, and I can't remember who I copied it to. So it was my copy of the BMJ. I read it, I looked at it, and I copied it. I can't remember who I copied it to. Would it have been Mr. Canavan, Dr. Pickles, and I don't know, Dr. Metters probably. I don't know who I copied it to, but presumably I copied it to them, because obviously Mr. Canavan won't have been reading the BMJ. I suspect Dr. Pickles and Dr. Metters would have been, but anyway, they may or may not have focused on it, but obviously from my point of view, because it was an important aspect, I photocopied it to them and I said, look, this is just so that you know that what is supposed to be quite confidential information is actually in the public domain. Because it also gave details of the payments, I believe, doesn't it?
I'm afraid I'd have to check, because that's not the issue that I wanted to explore, but we'll just have a quick look. Yes, it does refer to details of
you see, all of these things were supposed to be at that stage, you know, confidential, yet somehow or other they had leaked, or somebody had leaked them intentionally.
In any event, that's not, I think, relevant to the point that we're exploring,
No.
Dr. Rejman.
Yeah.
In relation to the document D,
Yes.
that is a document that was copied to you at the time.
Yes.
In relation to E, is that a document that you would have seen at the time? Or
No. I think, as I think I've tried to explain in my statement, when it came to discussions between the respective councils, that obviously I might hear little snippets, or if Mr. Fenwick felt that it was necessary for me to know something, he would tell me. I might hear a little bit more from Mr. Powell, who obviously I had much closer day-to-day contact with, but the precise details I would not be aware of, but I would be aware of the generalities. And as Mr. Canavan sent that minute, which was actually more than a month before my minute about Dr. Kernoff's patients suing the trust, I would be aware this is going on in the background. I wouldn't know all the precise details.
Now, those are the documents you've referred to that, in your statement, that predate your minute of the
Yes,
22nd
that's
of,
right.
of February 1991. Is it right to understand then that, as far as you're aware, and of course you haven't seen everything, you've relied upon the material provided to you either by the inquiry or for these purposes provided to you by the government legal department, but is it right to understand that your minute of the 22nd of February is the first explicit reference to relinquishing any claim for hepatitis?
I really do not know, to be honest. I mean, the fact, obviously hepatitis was the subject of my minute, so that's why I refer to hepatitis. And I say there, I believe, which means not that I think this will be a good idea to do this. It means that I understand from my discussions with others that this is likely to be what they will have to say. So I think that that is probably the sum total of my minute.
And if we just go back to your minute for a moment, DHSC 0004766_068. DHSC 0004766_068. It's right, I think, to understand the context of your minute was you'd had flagged up to you by Dr. Kernoff that there had been against the Royal Free some specific writs now in relation to hepatitis.
That is correct.
Is it right to understand then were you keen to ensure that the department did not find itself in the same position?
I think, well, reading that minute again, and I've read it a number of times, my understanding is I am here passing on information. I've had a chat with Peter Kernoff over on the phone, and he's told me, look, he's had a couple of writs about hepatitis infection in haemophiliacs. And I specifically say there that these are people who are HIV negative, so a different group from the one that we're talking about at the moment. And I said, therefore, that is the reason why they are taking out the litigation, because they would not be beneficiary, they would not benefit by the payment scheme. That is why they are taking out the litigation. And as a side issue, I say, by the way, I understand that people who have got the payments won't be able to do this. That's just a throwaway remark, basically, because that does not add to what the minute, the important bit of the minute, in a sense, is paragraph 1, paragraph 2, and paragraph 3, where he says that he does not believe DH is a named defendant. So those are the three paragraphs that are important. Paragraph 3, in a sense, is me just saying, oh, well, we all know that, or, I'm saying I believe, so, and presumably, if my interpretation were incorrect, Mr. Powell would have sent me a minute, copied to those individuals, plus anybody else he wanted to copy, to say, Dr. Rejman has got this wrong.
Do you recall being party to any discussions within DH at this time about the introduction into the terms of settlement of an express reference to relinquishing not just any HIV claims but hepatitis claims?
Well, I think that appeared in the trust deed at various times, because sometimes I was not involved in that, because I think there was a minute from me about the earliest version. This would have been 22nd of March 1991 or something like that, where I actually say that I think that the way it is phrased is too all-encompassing. It encompasses anything to do with treatment, which I thought was probably not correct. So I'm on record as having said that. And then, you see, I think the thing is, like with everything else, there were some things I was copied into, some things I was not. And in a sense, when you're sending minutes to people, you know, okay, we have had some minutes where the number of copy recipients has been 30, you know, 30. Now, whether all of those 30 really needed that minute or not is a matter of conjecture, but it may be that people are covering their back to make sure that everybody who needs to know does know, which I think is sometimes the reason for copy recipients. But usually, what I think most of us would do is, if we're writing a minute, and if we take this minute, for example, I'm writing this minute because I've had a chat on the phone with Peter Kernoff. He was a nice chap, you know, we got on very well. Had a chat, informal chat. He's telling me about this. He hasn't written a letter or anything. This is an informal chat over the phone. Now, obviously, none of the others would have been aware of that chat. Now, I could have mentioned it to them en passant, or I could have phoned them and told them about this. But if one writes a minute, there are two things. First of all, it is there, and I've actually had to think carefully, carefully, at least I've thought about what I'm going to be writing. Also, it gives me the opportunity to copy in people who I think ought to know. And in this particular situation, Mr. Powell was the important person. He needed to know about the writs. Mr. Canavan, probably. Mr. Dobson, well, courtesy. Dr. Pickles, courtesy. David Burridge, who John Canavan presumably copied it to, because he needed to know, because he was Mr. Canavan's junior, and as such had to know what's going on. So I think, you know, you can make too much out of these things, but I think when minutes were being sent about the draft settlement, well, the draft settlement, I think none of that came to mind, not very much that came to me. I think the draft trust deed, I got that. But if you look at them, you know, the copy recipients were different. Sometimes I was included, sometimes I wasn't. Sometimes I might be asked for an opinion, I might not be. Everybody might be asked for an opinion. And if you get a minute and you're put down as a copy recipient, you then have to decide, well, A, is there something important I can contribute? Therefore, I will write back and copy everybody else. I'll copy the person that sent the minute and all the copy recipients. Or you look at it and say, well, I've not really got anything to say, so I'll file it, and that is it.
I appreciate you can't necessarily speak to what other discussions may or may not have been happening on this topic elsewhere in the department or between council or so on. But would it be right to take at least from this minute that it was your view, hence you're expressing it in paragraph 3, that the settlement should include a relinquishing of any future claim to hepatitis?
No, this is my understanding that that is what is being discussed. It's not my view about what should be, because I don't say there that they should be. I'm saying there I understand that this is what people have told me, or, you know, in conversation I've gathered this.
And can you recall, and I appreciate again, obviously, in terms of recording conversations, it's a long time ago, but all the material that you've referred to in your statement up till this date doesn't expressly mention hepatitis. So can you recall any discussions about the particular issue that you flagged here in paragraph 3?
I have not, well, of the papers that I have been given, and that is what it boils down to, I have not come across any mention of hepatitis, no.
And then just for the sake of completeness, if we just go back to your witness statement, WITN 4486025. You make the point in paragraph 17, bottom of the page, that you were sent a minute on the 22nd of March asking for comments on the latest iteration of the trust deed. And that contained an undertaking that was solely concerned with HIV, is that right?
Yes.
And then if we go to the top of the next page, paragraph 18, you refer there to a minute, and I'm going to take it from your statement rather than go to the underlying documents, Dr. Rejman, just because you've set out the relevant passages, but we can look at any underlying ones if you want. You're absolutely right. You talk there about limiting the undertaking.
Yes.
But you're not talking, are you, about limiting it to HIV? You're talking about limiting it to HIV or other viral infections.
Yes, because in essence, the litigation was about HIV or other viral infections, because if you remember in the litigation, they referred to, I can't remember, other exotic viruses. Was that the word they used in the litigation? They do actually say that we should have been protecting not only for HIV, but other exotic viruses.
So your view, as expressed in the minute you referred to in paragraph 18, was that the undertaking shouldn't be so wide as to prevent any kind of claim, but it should be wide enough to cover both HIV and other viral infections, which would include but not be limited to hepatitis. Is that what you were suggesting in paragraph 18?
I presume what I'm saying there is the undertaking, as you say, is so wide-ranging that anything remotely, you know, to do with treatment of haemophiliacs would be covered by this, you know, no matter how remote, whether people sort of suffered because, you know, the bottle of concentrate fell on somebody's hand and they, you know, suffered a minor injury. You know, things which are completely remotely not connected with this would be covered by the undertaking, because the undertaking was so broad that I felt that it should be limited to what was the relevant context of the litigation.
Now, you said more generally in your statement, I think we can take it down for present purposes, Paul. If we need to look back at any particular passage, we will. But you've said that it was common clinical knowledge at this time, or indeed I think you say before this time, that most haemophiliacs treated with factor VIII were infected with non-A, non-B hepatitis.
Yes, that is correct.
Would you accept that that which is common clinical knowledge, and I think elsewhere you use the term scientific community in your statement, doesn't mean that the individuals themselves are aware that they are infected with non-A, non-B hepatitis or hepatitis C?
Well, I did actually at one stage in my statement make the comment that the vast majority of haemophiliacs would have been aware of non-A, non-B, because either they themselves have been jaundiced at some stage, or they knew of people who had been. And the haemophilia community being quite a close community, and people knew each other well, not only because they were in the same families, but obviously even within the same area. You know, people would chat, You know, if they were waiting in the clinic if there was a follow-up clinic, for example, and they're chatting in the clinic, or they were coming up for their supplies or whatever, they were forever meeting other fellow sufferers. And so I think the idea that haemophilia patients, or the majority of them, were not aware of hepatitis in generality, I think is probably not correct. And also the Haemophilia Society, I think in their various bulletins, refers to hepatitis. So the idea of people not being aware of hepatitis at all is one thing. Whether they were aware how much of the risk was to them individually if they had not been jaundiced ever, that is another matter, and I can't answer that.
With the greatest respect, Dr. Rejman, your last answers, I think, must be a matter of speculation, because you yourself had not, as you've been at pains to point out, had any great involvement with the treatment of haemophiliacs.
No, that is well, that is, yes, it's speculation, but I think one has to look at what is likely, and the likelihood is, and I know, because we do know that a significant number of haemophilia patients did become jaundiced. That is beyond any doubt. So at least those people would have been aware, because I'm pretty sure that any haemophilia patient that became yellow would have gone to their doctor. Usually they would have gone to their haemophilia doctor rather than to their GP and said, look, I'm yellow, what is the problem? And look, I'm passing dark urine, what is the problem? And they would have been told. The speculation really is how many people who themselves didn't have signs or symptoms of non-A, non-B were aware of it, and had they discussed it with fellow sufferers or not, that obviously best guess.
Sorry, not you, but yes. I'm not suggesting this was your role. Did the Department of Health, to your knowledge, take any steps to ascertain what the state of knowledge was of those who would be expected to sign the undertaking, either as to whether they themselves were infected with hepatitis C, or as to what their understanding was about the seriousness or potential seriousness of hepatitis C?
I don't think the department was involved in that sense. This was a discussion between the legal team, between council and their legal teams for the haemophilia patients and for the department. So I think a department was never specifically asked this. From the papers that I've been given, there is no indication that the department ever went out to haemophilia patients saying to them, are you aware about the risks of hepatitis C? Do you know whether you've had, nothing like that would have. And in a sense, you see, that would be an intrusion, would it not, for the department to be asking people that? Because after all, this is clinical information which is supposed to be governed by confidentiality, and to actually write to people and to say to them individually, look, are you aware? And in a sense, you see, the department has no right to even know who the patients are with haemophilia. That is not within their purview, is it? Because who has haemophilia has nothing to do with the department at all. The department is aware that there are patients who have haemophilia, and the people who know about who has haemophilia are the haemophilia treaters and obviously the GPs of the patients. But the department couldn't, for example, if they were going to send a letter, they'd have to send it to the whole population of the country and not just to the haemophilia patients.
Dr. Rejman, I'm going to move away from that topic now,
yes.
Because obviously there's still quite a lot we need to cover. But just before we leave the HIV litigation completely, there's one further document I wanted to ask you about. It's DHSC 0006480_080. This is August 1991, and you are writing to Mr. Canavan, copied to Mr. Powell and to someone else within the solicitor's office, setting out some observations about the medical negligence cases topping up. Now, in relation to that, can you just explain to us what the topping up refers to?
Well, my understanding, and as I say, this is a long time ago, but having read the various papers, my understanding is that the medical negligence cases were they were all against the district health authorities or regional health authorities, and in some cases against specific doctors. And from my understanding of the papers that I've seen, although the majority of the costs for paying for medical negligence cases was to actually come from the budgets of the DHAs and the RHAs, I understand that the department did contribute, and I don't know what proportion they contributed, but they did make a contribution, which is why the department was at all involved. Otherwise, they would not have been involved.
Well, that answers what was going to be my next question as to the department's involvement. As to your own, are you able to assist us in understanding why, in particular, you were commenting on these claims? Some of the comments you make might be said to be medical in nature, but others, if we go, for example, over the page, the second paragraph on the page, you refer to discrepancies in relation to a wife's supposed earnings in a fish and chip shop. I mean, what was it that you were intending to bring to the assessment?
Well, obviously I cannot remember exactly what happened, but reading this, I assume that what would have happened would have been that the health authority, if there was a particular medical negligence claim where they felt that the department might be prepared to top up, they would have sent the details to Ron Powell. Now, obviously, the name, well, I know that sometimes they did actually use the names, but ideally they shouldn't have used the names. They should, in fact, you see, the problem ultimately is that some of these cases were cases that were in the litigation and so had code numbers, and so therefore one could preserve confidentiality that way. And I think I do refer sometimes to people with, to code numbers. Sometimes, because they hadn't been in the litigation, therefore we had their actual names, which again was not ideal, and probably in retrospect one should have tried to avoid that. Anyway, be that as it may, I presume that the health authority would have sent, well, not all the papers, but a brief summary of the case to Mr. Powell. Now, Mr. Powell, not being a medic, and also not being an administrator, but being purely a solicitor, would have sent it on, presumably, I don't know whether they sent it to me first or whether they sent it to Mr. Canavan sent it to me, but I would have been the first person to look at the individual claim. And as you can see, these ones here, they're code numbers. There isn't a name, right? Now, if they had a code number, the chances are I had their individual statement of claim. And that individual statement of claim would have said things like, well, I went through it the other day about age, sex, married, oh, sorry, I didn't mention that, married, unmarried, in a stable relationship. That, again, would have been within the individual statement of claim. So I had the individual statement of claim, so therefore I had some information about these individual cases. So there was that information that I had, and there was information that we had from the health authority. Now, presumably, they would have submitted the actual claim from the claimant, which actually gives details about, you know, why they're making the claim. And a lot of this, in fact, is about subsidiary payments, etc. And so what I was doing here is they're using me not just as a medic, but basically, you know, there's a lot of work to be done here. And if you've got somebody who's actually going to be reading through this thoroughly, he might as well sort of comment about any aspects of the claim. Because I was a medic, did not say, you're a medic, you can't say anything about this. The understanding was I would read through the claim, I'd go through it, and I'd give my general view, I'd give my medical view about the medical aspects, and then if there are other things that came to my mind as a non-medic, but just as a general member of the public almost, I could say, well, look, this doesn't this doesn't sort of make sense. And then I would put that in my comment to Mr. Canavan. Mr. Canavan would then presumably not comment upon my medical comments, but he would look at my non-medical comments and say, well, no, you see, I think Dr. Rejman's view is, well, you see, he's the person, it's not me, he would be the person that would be taking the lead in non-medical matters, and he would say, well, having read what I said, he doesn't agree. And then he would actually say to Ron Powell, look, you've seen Dr. Rejman's minute, I've looked at it, and basically I think Dr. Rejman's got this wrong on the non-medical side, and that would be the way. So it was really a case of, everybody throwing in their two pennyworth, so to speak.
We can take that down, thank you, Paul. Did you see it as the department's role, whether or not by extension that then became your role, to try and cut down the claims as much as possible to ensure that the department paid out as little as it could?
I think there is a difference between saying we're trying to do this to do it as cheaply as possible and saying we want to do this fairly. And I think the department's role was to make sure that it was fair both to the claimant and also to the public purse. And I think it was a case of what was fair that was important. It wasn't just saying, oh, well, can we actually cut this down and save some money? It wasn't that. It was a case of looking at it in the broader context. Is this a reasonable thing to ask for? Or is it something that really we think, well, a lot of solicitors obviously will, as usual, put in for the maximum they think they can get, knowing that when the crunch comes and when the final decision comes, they will not get everything that they ask for. That is negotiation. And I think this is part of negotiation.
Can I move then to the...
May I ask, does it follow that in your comments as to the detail of the claims, that you never suggested that the figure claimed was too low?
I think, well, as a non-solicitor, I have to say this all the time, my assumption is that the solicitor, if they're worthy of their profession and they're doing their job properly, the idea that they would miss out on something which was significant, I think, would never have crossed my mind.
So you started with the idea that the claim was at the highest it could reasonably be put, or maybe even higher.
I think the assumption we made was that the solicitor was trying to get the most they could for their client, which is their job at the end of the day. And therefore, they would actually put in everything that they thought could possibly be claimed for. And I think the department's role, and I'd add my role only partly because obviously the administrators and the solicitors within the department and everybody else would obviously have in a lot of respects have a much more significant role in this. My role and others would be to look at it and say, well, does this look a reasonable claim? And I think most of these cases that are here are a minority because the number of I don't know how many people were actually paid in the end. It was over 1,200, wasn't it? Something like that. Was it 1,200 people were paid? Something like that. So 1,200 people roughly were paid. And the number of these cases that came to me, I'm not sure if you tot them all up, would there have been 20 of them? I don't know. But, a small number. The vast majority were paid, no problem. Oh, sorry, we're talking medical negligence. Sorry, medical negligence, there were about 80 or 100. Anyway, below 100 medical negligence cases. And the thing with the medical negligence cases were that the medical side of the medical negligence cases were looked at by Professor Hardesty, who at that stage was Professor of Haematology at Great Ormond Street Hospital. And he would look at it from the medical side point of view on behalf of the health authorities. I would look at it on the medical point of view from DH side, also bearing in mind that I might have additional information from the individual statement of claim, which Professor Hardesty wouldn't have had. So he didn't have as much information as I had, so therefore his advice might not give the whole picture. So I was asked to look at it with the advantage of the individual statement of claim information, and most of the time I suspect we agreed with Professor Hardesty's views anyway, because he was an eminent haematologist, very good, did the job thoroughly, although I seem to recall in some of the papers that we did actually say that he had not been given as much information as he should have been, even from our reading, that we thought the health authorities should have provided more information.
Yes, thank you very much.
Thank you.
So, Dr. Rejman, I want to move to the establishment of the HIV payment scheme for those infected through transfusional tissue. I think perhaps we can look only at a couple of documents for these purposes. DHSC 0003532_015. Now, we can see this is a briefing for number 10 from Mr. Canavan, copied to you and others, and addressed to Mr. Dobson and to the parliamentary branch. If we go over the page, we'll see the context of the briefing is that the detailed terms of the settlement of the HIV haemophilia litigation.
Yes.
And so that's being drawn to the attention of the Prime Minister. If we go to the next page, we'll see there's then a background note which refers to the settlement negotiations. I'm not proposing to go through that. If we go to page 5, we can see then this is a briefing in relation to HIV-infected blood transfusion recipients. The first paragraph says, government doesn't accept the case for no-fault compensation, recognise special circumstances apply to haemophiliacs, and there's reference there to the double disadvantage of the haemophilia and then HIV, and also to the fact that it can mean, because haemophilia is hereditary, it can mean more than one member of a family affected. And then the statement, the last two paragraphs, a similar combination of factors wouldn't generally apply to blood transfusion cases. In principle, blood transfusion cases are no different from other people who suffered medical accidents or the unintended side effects of treatment. So is it right to understand that at the point in time at which the haemophilia litigation was settled, the department's line in relation to those infected with HIV through transfusion or tissue was no financial assistance?
That is my, well, recollection probably is too strong a word, but I mean, say, reading the papers, I think that is probably correct.
And then there's a little more detail given over the page. So we can see the bottom of the page, paragraph 6, refers again to the double disadvantage of in relation to those who have haemophilia. But we go to the next page, top of the next page, the concerns that would appear in 7 and 8 are if we concede the position in relation to those infected through transfusion, we can't really ring-fence it to prevent a slide into a broader scheme of no-fault compensation. Was that your understanding of the department's thinking at the time?
Well, reading this, I mean, so I think it seems quite clear that, in essence, I think the government, as had previous governments, was very much opposed to no-fault compensation, even though this was something that was raised by a number of the haemophilia doctors and by others at various times, that they wanted a no-fault compensation because they thought this would solve all the problems. I think at the time when they decided to make the payments to the haemophilia sufferers, they decided that because of the unique circumstances that they were dealing with, this was a reason to make the payments. And at that time, the pressure from the public, the press, the MPs, haemophilia and haemophiliacs and everybody else was that this was a special case that merited a special treatment.
Now, that line to take is set out in the document we just looked at, which was May 1991. It's maintained in another document that you've seen, August 1991. I'm not going to take you to it. For the transcript, it's NHBT 5062_102. But we can see that the government's position then changed. And I just want to ask you about that. If we go to DHSC 0020274, this is a minute from Mr. Schofield.
Yes.
And so can you just assist us with what Mr. Schofield's role was? Or what HCA4 was?
Sorry?
Do you know what HCA4 was, which is...
As I've mentioned before, branches changed their names non-stop, and Roger Schofield was the Assistant Secretary who was in charge of the administrative branch that dealt with blood transfusion, because if you look lower down there, you see Mr. Canavan HCA4B, and my understanding is that HCA4 is the overarching branch, and then Mr. Canavan, which is the bit dealing with blood, has the B suffix.
And we can see it's addressed to the Secretary of State.
Yes.
And then we can see from the first paragraph, it says that the Prime Minister will make a statement in the House during question time tomorrow, stating that financial assistance will be offered to blood transfusion victims infected with HIV. Now, do you have either any independent recollection or any understanding, having been reminded from the papers, as to why and how the government's position changed?
I think any such decisions, whether it was the payments to the haemophilia sufferers or these payments, ultimately are made at a much higher level. I would say quite often people at my level get told this has been decided and just get on with making it happen. And I think and I mean, say, this isn't like when I suggested with the haemophilia payment, there was a change of government. There was something that might have influenced the decision. Here, well, I don't know. You see, there was a general election that was in the offing. I don't know whether this was at the time when you had these 5-yearly general elections. No, I don't think, no, this was before. So I'm not sure. But the general election did actually happen a couple of months after this, or less. So whether that had any impact on it, I do not know.
So if we just pick it up in paragraph 3 towards the bottom of the page, what's said by Mr. Schofield here is that the line we have taken hitherto, that the distinction between recipients of factor VIII for haemophilics and whole blood through transfusion is proving a difficult position to defend, and there's little public understanding or sympathy for the department's position. You're not able then to add anything from your own understanding as to how that shapes the department's thinking?
I mean, say, my guess, and I think at the time, most of the people at my level would have just accepted, well, somebody's made the decision, let's just get on with it because it's got to be done, type of thing. And I think here, what particularly prompted this, you see, I think one of the things with a lot of what was going on in the political sphere was it depended upon which particular MPs were pushing a particular line and how much influence those MPs had, primarily with number 10, but possibly also with the Secretary of State or other ministers within the department. So if you had a particular MP who was, and you had German debates and whatever, and there was a particular MP who was pushing for it, particularly if he was somebody from your party as opposed to the... See, if it was somebody from the opposition, you could actually sort of say, oh, well, you know, they're just doing this for party political reasons. Whereas if it's somebody from within your own party, and particularly if there's a body of other MPs from within your party that say, look, we think that this is something we should do, and if we do it, and if we do it well, with good grace, the public will appreciate it, and they will thank us for it. So I think it's politics at the end of the day.
Can I then come to the mechanics of the scheme, because you were involved in relation to that?
I was involved, very much so.
The decision was taken that the department would decide who was eligible for the scheme. And I think you'll probably have picked up from some of the documents that you've seen for the purposes of your statement. There was a concern expressed as to whether there was a tension there or a conflict of interest. Are you able to assist us in understanding why it was decided that the department would determine eligibility?
Well, I think I said in my statement that basically the number of patients that were likely to come up with this would be a small number. I don't know what the final number was in the end. Was it about 80 or something like that? I can't remember the exact numbers, but it was a relatively small number. The idea of setting up a completely separate unit outside the department, which would basically mean, I don't know, 2-3 people, plus the costs of office space, their salaries, their costs of travel and everything else. You know, there are costs involved. And at the end of the day, the other problem also is if you have a unit that is set up which has only a small amount of work that it's being done, then the people there might complain at a later stage, at some stage, look, we're wasting our time, and they may not even give it the time that is necessary because they say, oh, well, I'll do something else, and particularly if it's done on a sort of ad hoc basis. So I think reading the various minutes, my understanding is that a decision was made, look, the numbers are small, it's something that the department can cope with without too much difficulty, and so we'll do it in-house. And I know that there was this note of a meeting where the AIDS unit representative said they were worried about us making decisions, and I think, as I explained, the thing was that there was this panel that would make the final decision. So if an applicant put in an application to the department and it was turned down, then that applicant could then go to the panel, and the panel would be the final arbiter of whether they were paid or not.
So it's right to understand the scheme worked this way. The application would come to the department. Whilst you were there, you considered that application.
Well, in essence, the application was sent to me because I was named on the CMO letter.
You were.
So the application would have come to me, and I presume I would have then sent it to my admin colleagues, who would just check all the bits and pieces of facts where this is correct and everything else. And then we would have to get some information, because the application itself, I think the application form, I think we actually did include it, you included it in some of the papers from the inquiry, had very little detail. It had a name, the consultant, and also, I'm not sure it had a date, did it? I can't remember. I'd have to have a look at the actual application form, but it had very little detail. So obviously, to get the detail, one would need to get information from the hospital notes. And I think initially in the draft of how it was supposed to happen, I think the idea was that the hospital would send over photocopies or whatever. But I think in reality what happened was that, sorry, just to go back a moment, CDSC had a number of patients who they believe had actually contracted HIV as a result of blood transfusion recipient, blood transfusion, and they therefore had some information. So if an application mentioned that CDSC were aware of this, then obviously we didn't need to do anything at all about it. And if, on the other hand, there wasn't that information, and therefore we were starting with no information, we then had to get hold of the hospital notes or see them. And I seem to recall that in the early stages, I would actually travel to the hospital, look at the hospital notes, see whether in the hospital notes it said that they had actually had a transfusion, because obviously this was one of the things that was important, to make sure that they actually had had a blood transfusion, although usually, because they were supposed to be signed off by medic, then hopefully that would have been correct. But I gather that there were some applications that were not countersigned by medical professionals, and I would then actually look through the notes, check what had happened, the date of the transfusion, see whether there was any other obvious reason why they may have got HIV from another source, and then I would have to make any other further inquiries, such as going back to the blood transfusion centre and saying, look, this individual had blood donation, and usually we would, in the hospital notes, they should actually have the number of the blood transfusion. So therefore, we could actually go to the transfusion centre. Although normally, one would have expected that the claimant or the person claiming on behalf of the transfusion, on the claimant, would have actually contacted the transfusion centre, so they may already have actually checked that out. So it was a case of getting all the facts together as best we could. And then, having got all these facts together, then if they all sounded as though, yes, it's likely that the person got it from a blood transfusion, there's no other factors that are relevant, then there was a meeting, and I think I've referred in my statement to this, there would be a meeting between the solicitor, and I can't remember, it was Mrs. Edwards at that time, and then an administrator and myself. I would present the case, so to speak. I'd say, look, I've looked through this, this is what I found, this is what I found, this is what I found. And usually we'd say, yes, that sounds fine. And we'd send a summary to the Assistant Secretary, who would look at it, and he would sign on behalf of the Secretary of State to say payment should be made.
Do you have any sense of how many, what kind of proportion of cases were rejected or not accepted at that stage and therefore went off to the panel?
I think it was a small number, because I think in most cases it was pretty obvious and there was no reason to not to pay. Because at the end of the day, I mean, say one really had, you know, what were the reasons not to pay? Well, the primary reason not to pay was that they had not had a blood transfusion, or the blood transfusion was at a time when we already had screening for HIV. So they were post-October 85.
There was no cut-off date in the scheme, was there? So there was no date by which the person had to establish that the treatment had taken place?
Well, I don't know. I'd have to read through the actual words of the scheme. I think there was a bit of a cut-off in the sense that it said that if you are aware that you have got HIV, then, you know, within a year or so, you should really make an application, or at least make some sort of start towards the application. And
then in relation to the panel,
yes.
If a case went to the panel, it was chaired by an independent QC.
Yes.
They could hold an oral hearing, as it were, if they wanted, at which the applicant attended. There was the ability for the applicant to have a legal representative there.
Yes.
And is this right? There was no limitation or fetter on the kind of evidence that could be considered by the panel?
Well, the panel, if an application was turned down, I think in one of the cases that actually you highlighted, I would actually send all the information I had to the panel. So therefore, they had as much information as I had. So everything that I had was photocopied and sent to the panel, so they had everything. they would then, having looked at the information that I had provided, decide whether they needed more information. Because if they didn't need any more information, obviously there's no point in contacting the applicant. If, on the other hand, there was insufficient information for them to make a judgment, then they would ask, well, I suspect a lot of the time it was done in writing rather than calling the applicant to make a face-to-face meeting, because I think that's always a little bit less pleasant, because ultimately these patients, some of them were quite elderly, were ill for other reasons, or might have been ill because of the HIV even. So I think that the panel would probably have avoided asking them to come to the panel if at all possible.
Just so you understand, Dr. Rejman, and this is for your information rather than for a response, the reason I ask those questions is to draw out those features which might be said to be different from the features of the scheme that was established a number of years later after you left.
Yes.
The Skipton Fund, the scheme in relation to hepatitis C. So that's the reason for trying to understand the way in which it worked. Just then, I think finally, in relation to the this scheme, if we look at OXUH 0001251_004, this is the CMO letter from Dr. Coleman in April 1992, which drew attention to all doctors, well, all hospital consultants and all general practitioners, I should say, that this scheme was now up and running so that they could identify patients. As far as you can recall, were any other steps taken, either at this time or subsequently, to try and publicise the scheme? Was there any kind of press campaign or anything of that kind to try and ensure that as many people as possible who might be eligible knew about it?
I think there was a press notice, wasn't there, that was issued, I seem to recall. I'd actually have to look in my files there what else I said in my statement. I think there was a press notice, and I'm not sure whether there... which... Oh, that would be in 3. I don't know, you probably can find it easier than me.
Not necessarily.
There would have been a question from you specifically about publicity.
Yes, I can check that, Dr. Rejman, perhaps rather than take up time. I'm thinking more after the initial announcement with the CMO letter, and it may well have been accompanied by a press notice, and I can check that. Do you recall whether there was anything else done, or was the sense that the cases were coming forward?
Well, I don't recollect exactly, but reading through the various papers, my understanding is that the other people that would have been contacted would have been CDSC, obviously, and also the regional transfusion centre directors. And on top of this, I suspect there would have been communication with them and saying to them, look, CMO sent out this letter, but, you know, you really have to take this seriously. This actually is your job to do. So obviously CDSC, having their list of patients who were probable recipients of HIV-infected blood, then obviously they would have been contacted to make absolutely sure that all of their individuals had been contacted, or their or people, if they had died, then their personal representatives, etc. And I think the regional transfusion centre directors were aware, and I think, as we discussed the other day, one of the advantages of this being a Chief Medical Officer letter is that it guaranteed that every medical practitioner in the country, in all 4 countries of the United Kingdom, well, no, sorry, this is England, so yes. It's obviously England, this particular one, but each of the other countries had their own separate CMO letter, that each doctor was aware of the scheme, and we put down there, you know, ask, you know, if there's any suggestion that your patient has got HIV from this, and I suspect that probably a lot of the HIV clinics themselves would have looked through their records and said to themselves, well, this person doesn't sound as though he or she's got HIV from any other known factor. It might have been blood transfusion. So they themselves might have approached the patient and said, did you ever have a blood transfusion?
And the reference in your statement, I don't think I need to ask you to go to it, but just so that, again, it's clear, you deal with it in section 107 of your witness statement, pages 159 to 160. And you flagged up, for example, an instance in which you wrote to a clinician asking for details of the scheme to be brought to the attention of the personal representative.
Yes, because I think I'd been informed about that through another source, and therefore I felt that it was Professor Adrian Newland, whom I knew personally. So I wrote to him and said, look, I understand this patient may well have got an infection from blood transfusion. Could you fill in an application form for the patient so that we can assess this and actually pay the patient if it's appropriate?
So I note the time, and I'm going to move to a fresh topic, the ACVSB, after the break. So if we could take our morning break now, please.
Yes, well, let's do that and come back at 10 to 12. 10 to 12.